the party vote's the most important. Thank you very much.
The Honourable Christopher Finlinson.
I just want to take a brief call because some very serious allegations have been made about the course of this prosecution, and I think it incumbent on me as the senior law officer of the Crown to make a few comments about that, because they are serious allegations and this is a very serious matter. I support the motion for all the reasons that other members have referred to. We're very close to a general election. By-elections cost a great deal of money. For example, the Titai Tokoro one a couple of years ago is an example of where someone put the state to a lot of money to prove some principle to himself but not many other people. I too want to say something about Mr Banks. Wish him all the best for the future. It has been a humiliating period for him, made doubly worse this afternoon, I'm sure, by the prospect of his having to listen and being lectured on bad judgment by someone like Mr Mallard, whose entire career, or indeed entire life, has been characterised by misjudgments. That's the person who was convicted of common assault for, I think it was said to be punching Mr Henare in the House, but from my understanding it was more of a sort of an adolescent slap. But be that as it may, was one of a number of convictions. His head went down. Oh, you're right. This is the person who used to do girly weights at Bodyworks with Chris Carter, lecturing people on manliness. But Mr Speaker, oh, he's back.
Point of order, Mr Speaker.
Point of order, the Honourable.
Mr Speaker, I did do weights occasionally, but I didn't get my trainer to carry my drink bottle and towel like the member did.
Well, I'll have a bicep competition with that member any day.
I'm sure that will read well in Hansard.
But anyway, coming back to getting away from Mr Mallard's lack of biceps and coming to the real issue, I think we need to take the House very carefully through what happened in the course of this matter. And first, an important starting point, as the member for Rongotai will know, is the Policing Act, which she was responsible for when she was Minister of Police, and Section 16(2). And it makes it very clear that the Commissioner must act independently of any Minister of the Crown in relation to the enforcement of the law in any particular instance, and in particular in the investigation and the prosecution of offences. The law makes it clear that these cannot be political decisions, and some of the allegations that have been made over the last few weeks have suggested that it's got close to a political decision, which is a grotesque allegation in our democracy. So what happened was that a complaint was laid with the police regarding Mr Banks' electoral return. The police investigated and in July 2012 concluded there was insufficient evidence to consider a prosecution under the Local Government Electoral Act of 2001. Then Mr Macready brought a private prosecution in the Wellington District Court after police decided not to press charges. This private prosecution was brought by Mr Macready, came before a number of judges, including Judge Gittos, who decided there was sufficient evidence to commit Mr Banks to trial, and then the Solicitor General, the junior law officer of the Crown, utterly independently of anything to do with me, took over the prosecution and instructed an independent Queen's Counsel to conduct the prosecution. And the key point, Mr Speaker, is that at each juncture the justice system has worked according to proper process. And now that is all that can be said, because the decision in relation to the police is before Sir David Carruthers, and I would caution members not to get too far into that material, but I thought, given some of the frankly scurrilous allegations that have been made about political interference and so on, it was important to bring those salient matters to the attention of the House, because it could well be, Mr Speaker, that there should be a mature discussion next year in the context of the review of the electoral laws about whether or not there should be an independent political prosecutor. And I'd be very keen to engage in that discussion with the Labour Party, but I would say to them, with respect and affection, be careful what you wish for. Because, for example, in 2006, the police investigated the Labour Party's pledge card and leaflet, established there was sufficient evidence to establish a prima facie case in relation to an offence under the Electoral Act, but let the party off with a warning. In 2008, the police investigated a Labour Party pamphlet that was found by the Electoral Commission to breach the Electoral Act, exercised their discretion, did not bring charges. In 2011, the Electoral Commission again referred the Labour Party's electoral propaganda to the police, and Mr Robertson said the party had taken the view that the flyer was not an election advertisement. In 2011, the Labour campaign manager and former Minister Jim Anderton was referred to by the police by the Electoral Commission. The police exercised their discretion, no charges were laid. In 2013, Labour leader David Cunliffe decided to test the law by tweeting an encouragement to vote on the day of a by-election. No charges were laid, despite Mr Cunliffe's admission of responsibility and an apology. And I have to say I've got no particular problem with any of those decisions. The police were operating independently. They looked at the matter, exercised discretion and decided not to prosecute. Last year again, and this was not an Electoral Act matter, but Mr Goff breached a suppression order in a coronial inquiry, was let off with a warning, although other citizens have been prosecuted for doing exactly the same thing. And of course, I say to Holly Walker, there's Jolyon White, the social justice coordinator for the Anglican Diocese in Wellington, in Christchurch, who was investigated, and it still remains an open investigation, so one should be careful what one says, about vandalising all the National Party billboards, breaching the Electoral Act, and the police independently are looking at that matter without fear or favour. So, Mr Speaker, maybe we do need to have a discussion about an independent electoral prosecutor, and as I said, if I'm privileged enough to be back here after 20 September, I certainly would contend for that. But I would say to the Labour Party, be very, very careful. Be careful what you wish for, because that party's record is not all that flash. There is one party whose name is constantly being referred to the police for breaches of the Electoral Act, and that's the Labour Party. And I remind the House that it was Labour candidate Mr Singh who was sentenced earlier this year for his involvement in a case of electoral fraud where, unbelievably, he registered 51 votes at the same address in the 2010 Super City elections. And of course we all know about Mr Philip Field, but out of compassion and charity I'm not going to say anything about him. He's left this place. He can't answer for himself here, and I think that some of the purple prose placed in the direction of Mr Banks this afternoon was pretty unfortunate, to say the least. So let's have that discussion next year. These are important issues, and let us have a principled discussion in the context of the Electoral Act over these things. But I simply say to the Labour Party, time to get off the flea-bitten old nag, because when all's said and done, it's that party whose record over the years has caused so many complaints to the police.
Call Grant Robertson.
The Labour Party is, of course, supporting this motion. We do not believe that there should be a by-election held at this time so close